Our panel is Can We Just Play? The Legality of Let's Play Videos and Streams. Next slide. So I just want to quickly introduce my panelists. We are down one panelist. Sadly, Art Neal is very, very sick at the moment, but we hope he gets really better soon. I am Terry Karabanek. I'm a staff attorney with New Media Rights. This is Jacob. He is legal counsel for the Wikimedia Foundation with a specialty in copyright law and international litigation. He's also been an avid gamer since the age of 2. And Angelo is an attorney serving the video game industry, primarily independent video game developers. So before we begin, just a few standard disclaimers. We are not your lawyers. None of this is legal advice, really. We can't give you any legal advice in this setting. Also, tweet your questions using hashtag Let's Play South by Southwest. You can, of course, ask, we'll leave time for questions after the panel. You can absolutely ask them in person, but I'll be keeping track of any questions that are tweeted. And feel free to use the hashtag to tweet other things. Without further ado, do you want to start us off, Angelo?
Sure. Yeah, I just wanted to give a brief overview of intellectual property law, just so that we're all on the same page. It's something that a lot of people have to deal with a lot, but some of the terminology, it would be good to just sort of learn. So I took a panel from a Superman comic, just as an example of people getting the words wrong. Copyright, people use it all the time, but it applies to creative works. So you can use copyright to protect literature, art, music, sounds, photos, not a vaccine for AIDS, like Lex Luthor thinks here. Trademarks are used to protect identifiers for goods and services, like commonly names, phrases, logos, but even sometimes colors, sounds.
Even smells.
Smells, yeah. But those are used to identify where something comes from. And patents, which is not something that we'll deal with really here, but patents are used to protect inventions that are useful. So that's actually something that the vaccine probably would fall under. And so without further ado, copyrights, which I think is going to be the most pertinent thing to something like Let's Play videos and streaming. So as I mentioned before, what can be copyrighted? It protects creative works. So to get a copyright on something, it needs to be an original work of authorship, and it needs to be fixed in a tangible medium. Now what that means is, traditionally, let's say when you talk about something like literature, it's when you write it down, it's in book form, okay, great, but you can't copyright the idea. You can't copyright something that's ephemeral like that. It has to be fixed. So nowadays, it's a hard drive or a recording, something like that. So to use someone else's copyrighted work in your own stream or video, you have some options. You're not limited to only what you create solely and originally. The best way always is get a license. Get their permission in writing, yes, I have your permission to use your thing in my video. Second option, which Terry will talk about later, is fair use. It's a way for you to use certain copyrighted things, not necessarily with the permission of the original creator. And the third option is to use things that are already in the public domain. That means they don't have copyright protection on them any longer, either because they've been released into the public domain by the author, or they've just been around forever already and it's expired.
Yeah, and when we say forever, we really mean forever. Copyright lasts life plus 70 years, which is a really long time. So that means if you're under the age of 30, because of various copyright extensions, nothing has fallen into the public domain in your lifetime, which is a pretty scary thought. Which is why we need things like fair use, which is awesome and amazing. So fair use basically is the First Amendment balance to copyright. It says we really value copyright creators. We want people to create and be amazing, but as a country, we really, really value speech a lot. So we want to make sure that copyright doesn't stand in as an impediment to speech. We want to build in some flexibility. But fair use can be a little bit murky. There aren't any hard and fast rules that you can use. Instead, it's based on a balancing a 4-factor test, which can make it a little bit trickier, but we're going to break down that 4-factor test right now. So here are the 4 factors in legalese. Let's translate them. So the first factor is really looking at 2 different things. The first, which you're probably from, the first question asks, is my use commercial or non-commercial? Now, one of the big fair use myths is, oh, but if I'm making money off of it, I can never use anything in fair use, which is absolutely false. It's just part of one factor. If your use is commercial, it's less likely to be fair use, but it's not impossible by any means. If we look at probably the biggest recent example was in the Steve Jobs movie, where they reused that classic Apple movie in fair use because Apple refused to grant them a license to use it in the movie. The second part of this first factor is probably the most important thing. If you're not doing this, it's going to be really, really hard to make a fair use argument. That's transformation. So are you taking that copyrighted work, whatever it is, and transforming it, not just putting it in a new medium, but really changing the meaning, adding some new expression to it, so, which can be a bit of an abstract concept. So a good example is, let's say, let's take Weird Al for a second. While a lot of his stuff is satire, one of the best examples of fair use is his song Smells Like Nirvana, where he really takes Smells Like Teen Spirit by Nirvana and breaks it down line by line and is really making fun of each line for some of the unique things about the Nirvana song. Anything from, we can't understand any of the words you're saying, to other things within the song itself. So with transformation, really recasting and adapting it is absolutely key. Second factor is a lot more basic. So we look at 2 different things. First, we look at whether the work is creative or factual. So facts, as Angelo told us, aren't subject to copyright because we wouldn't want anyone having copyright protection on science or history for their lifetime plus 70 years. That just wouldn't work. But creative works do tend to get a bit more protection under fair use than factual works for that reason. But again, just because you're reusing something that's creative doesn't mean it can't be fair use. The second part of this factor looks at whether it's published or unpublished. So unpublished works get a lot more protection because your right as a creator is basically to decide if and when you ever want a work published. So like Mark Twain didn't want some of his works published till 100 years after his death, which for very good reason, as we learned recently, because he said some really, really nasty things about all of his contemporaries. So it would have been very damaging if that had been released during his lifetime. Now for games, doesn't really apply for the most part unless you get a game before it's released if you're a reviewer. Then you might run into that issue, but you probably won't run into this one very much in the field. The third one looks at how much you're using. Now you probably, and Angelo and Jacob will go into a lot of these myths later, but I like to break it down in 3 ways. First, you're gonna look at how much of the work am I using in total? Are you using a lot? It might be less likely to be fair use. Are you using a little bit? So the less you're using, the more likely it is to be fair use. But you have to not look at just how much you're using, but how much are you using in relation to the whole. So if I'm only using 10 seconds of something, but I'm just posting 10 seconds of the season finale of Game of Thrones on YouTube, that's probably not going to be fair use. And it also really matters what I'm taking. So bringing up the season finale, if you're using what's known as the heart of the work, so the catch of a song, or maybe that moment in a video game where you finally beat all the bosses and you get rewarded with this really cool end scene, the more central something is to a work, the less you'll want to use of it under most circumstances. That said, if you are transforming it, if you are providing commentary based on that, you can still use it. You just have to be very careful as to the amount in total that you're using.
A good way to think of that third one, by the way, is if you would have to put big spoiler tags on it, it's probably getting close to the heart of the work.
Right.
Yes.
And actually, I think it goes into this fourth one too, where the effect on the potential market. If people watch what you've posted and they don't feel like they need to buy the thing anymore because they've already seen what you've posted, you probably shouldn't post that.
Yeah, you'll see it a lot with lyrics videos on YouTube where people are like, oh, but I'm just posting the lyrics and the entire song. So, which can be interesting when it comes to Let's Play videos, since with, let's say you're playing the whole game through on a longer run, that raises some really interesting fair use issues. But even though we've just gone through fair use, it turns out for video games, fair use really isn't the entire story. But before I move on to that, a couple of awesome fair use resources. So New Media Rights, we made a fair use web app that basically takes you through the 4 factors. And then Duke's, many years ago, I guess now, put out Bound by Law. This is an amazing graphic novel that walks through fair use. I have used it with all of my students because it explains fair use really, really well. But, caveat, fair use won't necessarily always apply in all circumstances, because games are a little bit different. So unlike a book, or unlike an old school book or a CD, there's a end user licensing agreement that you have to agree to before you can even pick up the game for the first time. And some of those actually explicitly allow streaming or recording. Some will even call out, you can stream on Twitch and YouTube. Or some will say, you can use this in any way as long as it's not commercial. Or they'll say, you can use it in these commercial ways, but not that. So the thing about contracts is, if you're allowed to do something in the contract, that's basically saying you can do that. Fair use doesn't come into the picture at that point as long as you fall within those rules. The case law is a little bit murky as to what would happen if it came down to your use fell outside of whatever they said you could do in the EULA, the end user licensing agreement. But the really important thing to remember is these can change at any time. Any lawyer worth their salt is going to put in a phrase that says, basically, like, we can change these at any time for any reason that we want. So that's...
And without telling you either.
And without telling you. Though, if really you should, as a lawyer, you should be telling your users, because springing things on users after the fact when you made a change without telling anyone can make it questionable how enforceable those changes are. But it's always good to make sure you at least understand what the terms are. And I have to say, a lot of the video game companies have been awesome about this, and really putting their terms in things that are normal people language, not legalese, which I think is a great trend. And for any lawyers in the room, keep doing it. It's amazing.
Yeah, in particular, I think I like to call it like Riot's legal page has legalese and like normal human person words, like fully understandable, and also explains what their terms are. Minecraft, I think, also is pretty clear on what they do and don't allow. They also explicitly mention streaming and recording, and for commercial use too. So.
Yeah. The only thing to watch out for is in terms of what's binding, the legal version is what's binding, not the plain language version. And I haven't seen a lot of companies do this, but there have been a few cases where companies haven't been 100% straightforward in their plain language definitions. It happens, but it doesn't happen very often. So it can be helpful to at least look at the legal language. But again, just keep in mind the EULA. So I believe Angelo, or Jacob, were you doing?
Angela's doing trademarks.
Oh,
Angelo's
I'm
doing
doing
trademarks.
trademarks, apparently. Okay, so trademarks. As I said before, this is something that identifies you as the source of a good or a service. So it's usually a name, a logo, but it can be something a little bit weirder, like a color. Like I don't know if Twitch has a trademark on that shade of purple, but I actually wouldn't be surprised if they did. But the purpose of a trademark is to prevent confusion in the marketplace as to where something is coming from. So contrary to popular belief, having a trademark on a word or phrase doesn't mean that person owns that phrase and no one else can use it. Like, I think that comes up a lot in media. Like, well, when Taylor Swift copyrighted or trademarked 1989, oh, no one else can use that year anymore. No, it just means no one else can sell an album that's named that, or selling merchandise
Within the music.
Specifically within the music industry related to that and with that label on it. And yeah, that's the next thing I want to get to is trademarks are very specific to particular markets. So if you get a trademark, you get a trademark in a particular industry, like Apple. That trademark is for consumer electronics, or now they do a lot of different things too. But that doesn't prevent people from using the word Apple, selling actual apples or apple juice or anything. It's just in consumer electronics.
Yeah, and you've probably seen this come up. I believe it was Sony who tried to trademark Let's Play in relation to Let's Play gaming. Well, actually, someone had already beat them to the punch. A very, very small website that never really took off still has it trademarked. But the news articles when that came out were like, oh my God, no one can ever use the words Let's Play ever again because Sony has trademarked it. But
Right.
They hadn't actually finished the trademark application at this point. Trademarks, you have to, when you apply to the trademark office, there's a lot of back and forth. It's not like other things like copyright where it's usually you just send it in and there's not that much examining or going back and forth with the office. With trademark, there's a lot of push and pull between the trademark office and who's ever applying.
Right, and you can't trademark things that are like overly generic or just descriptive. So what ultimately came down to in the Sony case was they can't get a trademark on Let's Play for streaming and gameplay videos because that's what everyone calls them now. It's not something unique. The most trademarkable things are unique identifiers. That's why all of these Silicon Valley companies have weird, quirky names like Google or Weebly
or odd spellings of things.
Yeah, just things that sound different. Like they're not generic names. Like you can't get a video game and make a video game and trademark the name video game, because that's what everyone calls them, right? So they just have to be. You have to argue that they're somehow uniquely identifying the thing that you're trademarking. And I guess in the case of Let's Play videos, this would be your name, your logo, whatever catchphrase you're using to, what was that? Advertise. So those would be what identify you as a streamer, YouTuber, creator, content creator.
Mm-hmm. And the important thing to know about trademarks, if you're worried about, oh my gosh, trademarks cost so much, I can't afford a big law firm, the U.S. Patent and Trademark Office has actually set up a service where there are law schools across the nation that actually have trademark clinics where you can go to and they will file your trademarks at no additional cost. You will have to pay your filing fees, but they'll take you through the whole process, and even though they're law students, they're very heavily supervised by faculty members, so that can be a really good way to go to get your trademarks if you previously thought that trademarks were just out of your budget completely.
Oh, one more thing I wanted to mention about trademarks. It's not like copyright where if someone else has a copyright, you can't use it except for one of those other examples. You can mention someone else's trademark, or you can show their logo if, in certain situations. You just, because of the purpose of trademark, you just can't do it in a way that implies that you are, you can say Star Wars, you can talk about Star Wars, but you can't put a Star Wars logo on your thing and make it seem like you were the creator of Star Wars.
Yeah, and trademarks are really all about consumer protection. It really boils down to trademark laws there, so when you pick up a can of Coca-Cola at the store, it's Coca-Cola inside and that rat poison. That's primarily why trademark exists.
Right, and so someone down the street can't make their own soda and say Coca-Cola and have the average consumer think, oh, this is from Coke. This would be fine. Yeah.
Yeah. Yep. So that's pretty much it. So now that we've sort of gotten a lot of the basics out of the way, let's get into the fun stuff. Do you want to take us through emulators?
Yeah. So one of the first things we want to talk about is the use of emulators, which are becoming a lot more common in ways to play older games. But the thing about emulators is that they can make a difference for the law, which doesn't just look at what you're playing or what you're showing on a video, but also what platform you're using to actually play the game. And this comes up in a couple of different ways. One is the contract type of issue, the EULA issue that we've already mentioned, and the other one is DMCA issues. So I'm going to start with the contract side of it. A lot of EULAs especially for more recent games, actually will talk about emulators specifically, and they might have a term in there that says, don't emulate our game. So for example, if you look at the EULA for Battle.net, they actually have a specific thing in there saying, don't try and emulate the Battle.net servers, you're not allowed to do that. And what that means is that if you are using an emulator for something like that, the company might have a EULA claim against you, which could be a problem for making videos or posting videos. But this also gets into an issue with something called abandonware, or also if there's like very old hardware that's really difficult to obtain. And the classic example of something like this is if you've got a game that, say, has like a periodic check-in with the servers to run, and then the company stops supporting it, then that's a game that becomes impossible to play without using some kind of emulator to actually play it, because it just wouldn't function on its original technology anymore. In a case like that, there might be a really good argument that the EULA wouldn't apply, because if the EULA did apply, the entire thing would just be unplayable and it would frustrate the whole point of buying the game. Looking at then the DMCA issues.
So what is the DMCA?
Oh yes, thank you. So the DMCA is the Digital Millennium Copyright Act, which is a bunch of provisions in and around copyright law that put certain limitations on what people can do. In the case of emulators, there's a specific section of the law, 17 United States Code, section 1201, which says that nobody is supposed to circumvent technological protections or to traffic in technology that is designed primarily to circumvent technological protections that are there to stop things from being copied. But this is a bit complex when it comes to emulators. And it's complex both because it's hard to tell what emulators are and because there are some exceptions to this. So if you're looking at an emulator, is an emulator something that is primarily designed to circumvent technological protections? It can do that, but there's also a pretty good argument that emulators are there to let people explore a particular kind of hardware, a particular game environment, and they can be used for people to create their own designs or play around with other things and learn about how games work in a way that would not be a violation of the law. Similarly, the DMCA has an exception for non-infringing uses. So for example, making archival copies of things you already own is not a violation of the law, according to the Librarian of Congress. And doing things that are new or different, things that might fall into fair use, as we already discussed, are not a violation of the law. So one example of that might be things like speedruns or save states. For example, if you look at tool-assisted speedruns where people are doing a frame-by-frame slow motion version of a game to figure out the most optimal way to play through that game, that's something that can't be done on the original hardware and requires some kind of emulator to even undertake that sort of effort. And when you're doing something like that, there's a good fair use argument, there's a good argument that it's not infringing the law, and therefore it wouldn't run afoul of the DMCA either. However, it's worth noting that this is an area that hasn't been too well explored. So something to think about is if you're using an emulator to just play a game that you could be playing on its original system, you could run into trouble. But if you're doing something that is really new with it, something that is like tool-assisted speedruns, or using save states, or otherwise playing a game that would be impossible to play otherwise, then you're probably in a good spot.
I mean, I think this is coming up a lot now, especially, like, for example, original Nintendo games, the NES games. A lot of people use emulators for stuff like that. But, before you could make the argument, well, it's hard to find these, and, a working console. But now, most of those games are available on the Nintendo eShop. So they would definitely come and say, just buy your game and play it on a Wii U or whatever. So it makes it harder to make that emulator argument in cases like that.
All right, the next one we want to talk about is the top 5 fair use myths. So we already gone over the factors for fair use, but these are some things that you'll often see pop up on people's videos or other things they're doing. And we're going to try and go over how these work. So the first one is, I'm not making any money. As Terry already mentioned, that goes both ways on fair use. That is, you can do a fair use even if you are making money, but if you're not making money, that doesn't automatically mean it is a fair use either. If all you're doing is copying an entire game, or if you're just like putting an entire song onto YouTube without anything else, that's still not a fair use, even if you're not doing it to make any money.
Did you guys hear about this remake of the Star Wars Knights of the Old Republic that was announced a little while ago? No? Some indie developers have announced that an intention to completely remake Knights of the Old Republic in HD for modern machines, 3D, everything, like high-res textures, without the permission of the original developers, BioWare. And their main thing on their website was, we're not going to make any money on this, so it's probably fine.
Yeah.
I think Disney and Lucasfilm and EA might think differently about that.
And honestly, most copyright lawyers on both sides of the aisle
Right.
on that
right.
one.
Yeah, just because, I'm sorry,
So what about Happy Birthday?
Oh, that is.
That's a copyright.
That's a copyright.
And that's a really interesting case. I don't know of the settlement. So what happened in the Happy Birthday case was, okay. Oh yeah, and in the future for questions, they're asking if you can come up to the mic because it's being live streamed, and we can't quite capture you. But the question was, what about Happy Birthday? Well, Happy Birthday, what happened in that case was essentially Happy Birthday probably had fallen into the public domain, but was being licensed out anyways. And in that case, we saw something that we really haven't seen before, a settlement agreement where both parties came together and said, we, agree on the record that this is in the public domain. So I don't know if the court has approved that settlement yet.
I think it did, but there was like a third party that wanted to appeal somehow.
Yeah, so I think there might be a little bit left there, but it's definitely a very unique case. We haven't seen anything like that in a while.
Also worth noting, in fact, I'm just going to jump to the last one on the slides there about old games. So Happy Birthday was very old, and the reason that it got into a big lawsuit was that they weren't quite sure how old it was. It might have been so old that it was in the public domain, but it also might have been done a little bit more recently than that, which was what could have allowed them to still have been licensing it out for a few more years. Games, on the other hand, even the oldest games that are out there right now, are still far too new to be in the public domain. So even if a game is really old, that doesn't mean that it's out of copyright and that you can just use it however you want.
Right. Like a really old game is like a game from the 1970s, right?
Yeah.
So
Yeah.
copyrights on video games aren't going to start expiring and going into the public domain until 2050 or so?
At the earliest.
Or at the earliest. Like when we say old, we mean like Sherlock Holmes old. Like
Well, not even all of Sherlock Holmes
yeah,
old.
like
We mean like
the early stuff.
the Bible old.
Yeah.
There. Like
we're not
musical compositions from the 19th century will probably be good. But
The very early 19th century.
yeah, we're like Beethoven, okay.
Yeah,
Yeah,
Beethoven, good.
I bring up Sherlock Holmes just as an aside because it's an interesting case where the first section, like I think more than half of Sherlock Holmes, the original works, are now in the public domain, but the later bits
Yeah.
they still have copyright on them. So
Yeah.
people have gotten into trouble trying to use all of that in their own stuff.
Yeah.
All right. Going back up, so we also have, you may see people put disclaimers like no copyright infringement intended, but as we mentioned with the making money side of things, it doesn't necessarily matter what your intentions are. The question that copyright law looks at is whether you are or are not using somebody else's work. Even if you don't plan to do anything bad with it, you need to get their permission to use it if you want to use it.
Yeah, and you'll also see a lot of people just copy and paste in the statute. Your ability to copy and paste isn't one of the four factors.
It just shows that you know which statute you're violating.
Yes.
This one is always really funny to me because it makes no sense. I can't wrap my head around it. It's like I can't drive down the street in a stolen car with a sign that says "No grand larceny intended" and think the cop is gonna, oh well, you didn't mean it.
For not archiving the stream, that one it's partially a myth, I would say.
Yeah.
So people will think, oh, if I'm just live streaming and I'm not making any archive, there's no permanent copy, then there's no problem with this. But that's not quite how it works. So copyright has several rights in it, including not just the copying, but also publicly performing a work. So if you're doing a stream and you're showing a game or cutscenes or something to a large group of people, that could still be a copyright violation, even if you're not making any permanent copy of that. But that said, it is a lot harder to find people that are just live streaming and making no permanent copies. They're generally not wandering around on the internet clicking on random streams to see if they're showing any copyrighted content or not. So it is a little bit harder to find someone who is only live streaming and not archiving. However, if you are caught, that is still a copyright infringement. It doesn't help you as far as the law is concerned.
Yeah, I want to bring something up here. The fact, if as a streamer, if you're streaming on Twitch, let's say, and you don't archive your stream, then it would be hard to say that you could have or it would be hard to enforce a copyright on your performance, like on your
But
performance in the
it
stream.
can be done in a handful of circumstances. We saw when Periscope was becoming really popular, it depends on how long your stream is going on. For example, during the Game of Thrones became a really hot thing to put on Periscope, and of all things, and HBO was really quick about shutting down those streams. So with video games, it's a little bit harder since it's not like there's one event everyone is watching at the same time. But streaming is still.
Yeah. Oh,
Well-
I just meant as a performer. If
Oh,
you,
as a
as
performer.
if you're the streamer, you could claim a copyright on your
Oh,
performance
yes,
or
yeah,
whatever
yeah.
if it's recorded. But if it's not, then as I said earlier, like it's not fixed in a tangible
Oh,
medium,
yes.
so it's harder to
Oh, sorry.
get a copyright on
Totally,
your own thing.
yeah.
But
So
yeah,
that'd be like
you're
if you
performing.
were if you were talking and like doing a review of a game or something, your own review.
Right.
If you don't record or save it anywhere, you might not get a copyright in that. But if you do keep like a video that you put on YouTube of your review, then you could have a copyright in your own review. So last one of this set is the "but I gave them credit" argument. Unfortunately, that one falls into the same problem as the disclaimers, which is if you took something without permission, it doesn't matter whether you know who you took it from or let other people know who you took it from either. It's the same thing as like, you know, I stole a car and it belonged to my neighbor Mary. Doesn't mean that you didn't steal the car. What giving credit is really good for is getting people to give you permission. There's a lot of people out there, especially for non-commercial projects, that are more than happy to let you use something if you ask, and often all they want is credit, so offering that can be a great way to get someone to let you use a game.
So now we're going to talk about music and streams, which is a really hot issue at the moment. Probably for the majority of you, most of the music that you'd want to use in your stream would be copyrighted. We're not talking about really. There don't seem to be a lot of people playing games to Mozart. There are probably a handful, but there probably aren't that many of you that fall into that category.
More people should.
More people should. Actually, that should be a thing. Let's play to Mozart. Let's make that happen. But even if you can't, starting from the base point of all music is copyrighted, that means you either need to have permission, have a license, or use it in fair use. Using music in your stream under fair use is really, really hard to do because most of the time when you're doing a Let's Play video, you're not really addressing the music in your stream. People aren't coming to your stream for the music, they're coming for you to play and be awesome. But there are a couple of ways around it where you can actually find some really great music to use that you don't have to worry about your stream getting taken down or your video getting flagged on YouTube. Twitch and YouTube both have pretty big music libraries. The only thing to watch for these music libraries is that most of them only have permission for a limited time. So it's entirely possible, and we've seen this happen a couple of times on YouTube, where YouTube got permission for 5 years, and on the 6th year, if your video is still up, your video will be flagged because that music is no longer licensed by YouTube. So that's the only thing to watch out for there. But a lot of music is available via the Creative Commons license, and Creative Commons is an awesome thing that basically sits on top of copyright, and it allows artists to be able to say, hey, copyright's complicated. I realize that going out and licensing my music with all of you is probably not a feasible thing for me to do, but I want to let you use my music under certain circumstances. And that short link is a link to a list of a bunch of Creative Commons music and royalty-free music. It's really, really helpful. We try to keep it updated relatively regularly. Another option is getting a license. And while you might not be able to get a license from Beyonce, there are a lot of independent musicians that are often very eager to work with Let's Play videos, since you guys are getting some of, while Let's Play views haven't reached the same as TV, there's still a lot of views and a lot of eyeballs on these videos. So it's becoming a really great place for musicians to advertise and to make a name for themselves. The only thing to watch out for here is always get those things in writing, always. And it can even be a good idea to even go to a lawyer, go to a law clinic, go to someone like New Media Rights once, and work with them on a template music license that you can use. Because often when you reach out to indie musicians, they won't have a music license. So if you have a written license already written up to hand them, that can work really, really well. You may also want to mute your music, the in-game music, since in-game music licensing is a little bit funky. In a lot of older games, I've heard from older video game attorneys that it used to be a pretty common practice for designers to walk up to them the night before launch and say, so we used 5 top 40 songs in the game, is that going to be an issue? So you can imagine on the night of launch, you're not in a great position to be negotiating for anything. So the licenses that most companies have for the music in their games, especially older games, is really limited. Now that we're in the age of streaming, they tend to be a little bit more expansive, and some do and some don't. So it can be best, especially if you're posting on somewhere like YouTube that has Content ID, to just mute the in-game music just to err on the side of caution, just so your videos don't get flagged.
Right, like there's a difference to note here between just the background music of a game versus when a game uses popular like music. If you're playing the radio in Grand Theft Auto and you're playing actual songs that have been on the real radio, that you don't want that on your stream either. Just it being in the game doesn't automatically make it okay to play in the stream, because it's going to get flagged by something.
Yeah, and studios will vary. A lot of the bigger studios, the in-game music that you hear that isn't like a radio playing is owned in-house, so that can be okay to use. But with a lot of indies, because I've worked with a lot of independent video game developers, they don't always get the music properly licensed.
A good example of that is Super Meat Boy, I think, actually.
Yeah.
If you guys are all familiar with that game, you may have noticed that when it came out on PS4, the soundtrack is completely different than when it was on PS3 and PC. And that's because the original license for the music didn't cover other platforms. And I think they tried to renegotiate or with the music creators, and it just turned into a whole thing, and they were just like, new music.
Yeah.
It's also really common that they'll get a license for the music in the game, but there's no license to like broadcast the music, so that if you are doing a channel that has a lot of people viewing it, that's seen as something that is different from just playing the game like one person for each copy of the game. And so that's a problem that you can run into.
So we've talked a lot at you this hour, and we wanted to leave plenty of time for questions. So if anyone has any questions, please come up to the mic, and we will be happy to answer them. Just one last disclaimer, we can't give you legal advice in this setting, even if you ask really, really nicely.
Hello.
Hello.
I apologize for being really late for this, because I really wanted to see it. So there's quite a lot of debate in legal theory, in a paper a couple of years ago I was trying to look at, talking about gameplay in general, in all senses of game, and because of the nature of the limited rule set, it fails the originality test under IP, therefore gameplay itself, and therefore the streaming of gameplay, copyright does not obtain. Now, I thought that was kind of a bit wacky as an argument, but then the recent EU decision a couple of years ago on a Sky TV broadcast cards. That was actually turned on that particular point of law that they said football, because it was rule-bound, wasn't original, and therefore the gameplay itself did not have any inherent IP within it. I'm sorry if you covered that earlier, but I'd be interested in your thoughts.
Oh, no, we didn't. And that's a really interesting issue. So unlike more traditional games, so a lot of the early video game cases were on things like Atari, where there wasn't a lot you could do. You could move your paddle up and down, and that was it. And when courts were looking at that in the 80s, they said, okay, for gameplay, there's not really enough for originality. But now that we have really highly immersive games, sandbox games like Minecraft, where the user can really interact a lot more, courts have actually been willing to grant copyrights to gameplay and to look at that as a copyrightable work. Whereas real-world games, where you can only play soccer so many ways. If you make up your own rules to soccer, that doesn't tend to go over well with the refs.
Right, there are a lot of games now that your creativity in playing the game is a big part of the appeal of the game. I mean, Minecraft is the best example I can think of, but I mean, there's a ton of games in that genre now. So I think things have changed a lot since then. And then as far as Let's Play streams and videos, a lot of the creativity also, I think, comes from the commentary. Are you critiquing, or are you, is there some aspect of you that is going into this performance?
It's also worth noting, I think, that copyrights in games are kind of like the whole game overall. It doesn't, like, it might vary game to game how broad that copyright is. Like, for example, lots of games have people that jump in them, and if you make a game with characters who jump, that doesn't stop anybody else from making a game with characters who jump. Like, copyrights are not that broad. I think probably even something like, very strong action hero that's a crack shot and can take on a small army by himself is way too broad for anybody to get a copyright in that, right? That story can be told by almost anyone. It's when you get really specific into, like, you have this character who wears, this set of clothes and has this weapon and all that sort of thing is where you start to see the copyright in the game, and you can't copy that.
Right. There was an example when Street Fighter 2 came out that I think it was a game called King of Fighter, or I'm forgetting the title, but there was another game that came out right after Street Fighter 2. All of the characters looked very similar to all the original Street Fighter 2 characters, and then when it went to court, they looked at the original design docs, and the design docs for the second game all referenced a lot of Street Fighter 2, like, let's make it look like this character. So that's less okay.
Yeah, and that's just a thing. If you are designing games, you shouldn't have a lot of. It's bad to have emails that say, "Let's make our game look exactly like this game."
Don't write it down.
Don't write that down. Yeah. Never.
Waldo?
Hi, I'm Wesley with Namecheap. I have a two-part question.
Okay.
There are a lot of consoles that allow you to stream directly from the console itself.
Mm-hmm.
So the first part of the question is, do you still need to have the game maker explicitly say it's okay to stream it? And two, does that stream, because let's say it's implied that you can stream the game, does it lock that stream to that third-party site? Could you stream it on a site that you choose to, not the PlayStation Network or whatever they might lock you into?
Oh, that's a good question. As for the first part, I know that you mentioned PlayStation specifically. It mentions in the EULA of the hardware that they allow streaming, but that it might vary from individual publisher or whatever, so that each publisher might also have something against streaming or recording. And I think some games actually even prevent that functionality depending on the game or what part of the game. Like if you try to hit the share button on your PS4 controller in certain parts, I know some games will just give you like a red X in the corner. So it does vary, and you still have to look at the license for each game.
Yeah, and this really gets back to the distinction between the contract stuff and the copyright stuff. So the contracts, both for the hardware that allows for the streaming as well as the individual games, will say whether they allow for streaming or whether they might allow for streaming or whether you definitely can't stream. And then separately, there might be a question of the copyright issues. So copyright, for example, you might be perfectly fine under copyright where you're making like a review of a game or something that is very clearly like your own personal and unique commentary on the game, but then you're still violating that end user license agreement, and that could be an issue. also, going back to the thing I was talking about in emulators, the part about getting around technological protection measures, if there is something that is like built into the game that will stop it from working if you try to stream it on any other system, building a tool that bypasses that could be a problem.
I think that ultimately also comes down to the specific terms of the license, but I haven't seen anything, at least just anecdotally, I don't remember seeing anything that says if you stream it from our platform, it belongs to us and you can't stream it on anything else. That might change though if you are, for example, let's say you're a Twitch partnered streamer and you have a contract between you and Twitch, then it's up to what's in the contract between you and Twitch. They might be able to say, since you're a partner streamer, we want you to we want to lock you to our platform for whatever reason.
I think that about covers it. Any additional questions from you guys?
Because we can always talk more.
Yeah, we have a couple more things if you want us to talk about more stuff.
Yes, and we don't seem to have any more questions from Twitter, so do we want to bring up the bonus category?
Yeah, this is one I actually was going to bring up as far as what's more likely to be a fair use. I think we've already kind of touched on this a little bit, but if you're playing a game and you're commenting on it, you're critiquing it, that's you putting something original and transformative into it. As opposed to, let's say, if you're just playing a game that's very story heavy, has a lot of cutscenes, and all you're doing is showing all the cutscenes without you saying a word, that's a lot less transformative, and that's a lot more like a substitute for the original game. And
Can I ask another quick question? So what about if you want to use game heroes or parts of a game when you're trying to motivate your sales team in your office?
That's a little bit too specific for us to answer in this setting, unfortunately, but we thank you for your question.
But yeah, in general, copyrighted characters and things, you don't tend to want to be using them to promote or anything. I do recall something at the last year's PAX in Seattle where a fan organized event that like a party was using Pokemon characters to promote their party, and that got shut down by the Pokemon legal team because they were using copyrighted characters, like actual images from Pokemon, to advertise for their party, which is not good. I mean, also like Pokemon didn't necessarily want to be associated with an after party where they don't know what's going to happen. Alcohol's
And there's like some trademark overlap there too. So specific characters like Pokemon, for example, can be both copyrighted and trademarked. And so there's like, we own this character and you're not allowed to use it on the copyright side, but there's also the trademark aspect, which is, like Angela was saying, like Pokemon doesn't want to be associated with certain things like a really late night after party necessarily, and they don't want people to get confused that like Pokemon is sponsoring an after party or something. So that gets into the trademark side of it.
Right, like Mickey Mouse is copyrighted from the old cartoons and everything since forever ago, I guess. But even when that copyright, if it ever does expire, if they allow it to ever expire, if they don't change the law.
Well, there is a lot of talk about copyright reform right now, and
Right.
Mickey Mouse's copyright is coming up soon.
Right, but even if that copyright does expire, the Mickey Mouse logo and everything, and it's still trademarked, and that will be eternal probably. It will outlive us all.
As long as they get their filings in on time and pay the trademark office, which they probably will.
Another thing I wanted to bring up about streaming or videos is something you can also do to make it more transformative is to add overlays and graphics. If you're adding your own, sounds and animations to, let's say, when there's a new follower or something, that's another thing that kind of helps just kind of add a little bit of transformation, originality to.
And Yeah, and that doesn't just help with fair use issues, even though admittedly most fair use issues are knocked out by EULAs, except in the case of indies that might not have that built in. It also just helps you create a better brand, since the reality is there's a lot of competition for you guys now, so it is all about creating your own personal brand. I'm sure there are a ton of sessions on that here at South by. So the more you can do to make yourself original and different than everyone else playing the game that you're playing, the better.
And that can apply even beyond just like commentary. So you can have commentary, you can do like graphics that you put on your videos on top of the game, for example, or overlays. If you do like a face cam while you're streaming, all that sort of thing can add more original content that you're adding and make it both better for your brand, and you're using less of the copyrighted stuff overall, which is helpful from the legal side.
Right, like, yeah, I've seen, not so much streams, but gameplay videos where it's just a recording of all the cutscenes in the game, which if you just wanted to see the story, why would you buy the game after you watch that video?
Can I ask if you, sorry, I
Oh,
missed
no,
it.
no, go ahead.
If you did cover any international issues, because, you know, I have people in the UK and the EU asking me about fair use, and I have to say, yeah, we don't have a fair use doctrine in the EU. So it doesn't apply. So if there are any UK streamers or anything like that?
Oh, that's a good question.
It
So
depends.
I know a little bit about it. So like Australia, for example, has an exception called fair dealing, but it's much more narrow than fair use in the United States. It's usually limited to things like reviews and news reporting only. And I don't know a ton of details about it, but I know it's much more narrow. Europe also doesn't generally have the same kind of fair use exceptions. So you have to be a little bit more careful there in terms of what's allowed by the EULA and what's not, because there isn't that fallback.
Yeah, and then Canada has an interesting sort of two-part system where you have to fall under certain categories, and then there's a more similar to US style four-part test that's applied. So it really varies by country to country, but the good thing is in Europe and across the globe, there are actually an increasing number of law school clinics that are popping up that can answer these questions if legal counsel isn't available.
Yeah, we are but humble U.S. attorneys,
Yes.
so we don't really know much about. It's hard enough learning all of the U.S. law sometimes that, yeah, unfortunately we can't comment more on international law. But that's a good question. I mean,
Yeah.
streams and videos, like the barrier to entry is so low that anyone with a laptop and a good internet connection anywhere in the world can be doing this. So
Yeah, and that's one of the big copyright problems that's coming up in this kind of new digital age is in the old days, it was very easy to bind things to a certain country. You can't do that anymore, and unfortunately, licensing hasn't really caught up to that concept.
I think though, as far as streaming though, because there's really only two major platforms for it. I think Twitch and YouTube Gaming, if you want to call those the two
Yeah.
main ones. Those are kind of locked to the U.S. So
Yeah.
even if you're elsewhere in the world, I mean, there's going to be other laws that apply. But if you are streaming on Twitch, you are bound by all of the terms of use between you and Twitch. So there, international law gets kind of tricky.
Murky there.
But the U.S. law will still generally apply to a lot of that.
And I think I don't want to get too into this, but the U.S. exceptions do apply to a lot of these sites. So if YouTube flags something under Content ID and says this is a copyright strike against your account, they have a thing saying you can appeal that and say this is a fair use, and they evaluate that under U.S. law, even if you, the video poster, aren't necessarily in the United States. That doesn't mean you're scot-free, though, which is why I'm hesitant to get too into it, because you still might be subject to the laws of wherever you happen to be, and they could sue you that way. But that might be a lot more effort for someone, and just flagging it on Content ID and taking it down isn't necessarily allowed through those international laws.
Any other questions? We have about 5 more minutes, and we'll also stick around after the panel if you have questions that you don't really want to ask in a huge conference hall setting.
Yep. Okay. We have one more little thing we could do.
Yeah.
If you had, So to just kind of finish up, one of the things that comes up these days is the use of games as tools. So for example, if you've seen any of the level maker games, a lot of the stuff in Minecraft, Super Mario Maker, and a question sometimes comes up, which is, do you own the levels and mini games that you make? The answer to that, unfortunately, is probably not. Most of them have something in the license agreement for these tools saying that the content that you're making is either something that you're giving ownership of to the company that makes the game, or if you own it, you're giving the company that makes the game some kind of worldwide, irrevocable license to use it forever. And so at best, you might jointly own it with them. This is a pretty limited thing because you also can't go use it by yourself somewhere else since it's made of art and other things that are copyright of the original company. So your work is essentially like a derivative work of the game, and so you might have a copyright in your creativity, but it would be limited because it's derivative from the original, so using it elsewhere would be a copyright violation. There is a sort of weird niche case, though, where you could own a copyright in your creative thing, and if they took your level and adopted it into something else without your permission, you might be able to stop them from doing that even though you couldn't use it anywhere else either, in which case you could like negotiate a license with the people who wanted to use your game level in the next game they were designing. The last thing to keep in mind with games as tools is that when you have the freedom to create levels, you need to make sure you're not infringing other people's copyrights or trademarks. So for example, if you design a level that is a giant, perfect Mickey Mouse face, you might run into some trouble, and Disney will be very unhappy with you.
One more thing. This reminded me that I wanted to cover real quick. It's not exactly Let's Play, but I am seeing it more and more on streaming sites like Twitch, where people aren't exactly just streaming gameplay, but now people are streaming actual game development, which is interesting, and then they actually solicit contributions from their followers and people in chat. This makes me really nervous as an IP attorney because there's a lot of unanswered questions as to legally what does that mean. I mean, the idea of it is great. It's it's collaboration. It's sharing with your community and getting hype about your product when it comes out. But who owns some of these ideas when they came from someone in your audience and you're using it in your code?
And it might not seem like a big deal now, particularly if you're a smaller developer, but if everything goes amazingly and your game turns into a runaway hit, that's when it really becomes a problem, because there's an old saying where there's a hit, there's a writ, which basically means when you make lots of money, people will come try to take that money if you don't have contracts in place. And that brings up another point too. Anytime you're working with a team, if you work together to create something, your team collectively might own it. So if you haven't talked about ownership issues with your team, and if you don't have that in writing, that's something to do very, very quickly. And if you can do it, if you're just starting to create, do it as soon as you can. Do it up front. And a lot of people say, oh, but I don't want to do it. They're my friends. I don't want to hurt feelings. Honestly, contracts tend to save friendships. And not having a contract, I've seen it in a lot of cases where it just destroys really strong friendships.
Yeah, if you're a YouTuber or a streamer and you have someone do the artwork for your logo, for your banner page or whatever, have a simple contract for that and just outline what the artist is okay with you doing and not doing with that.
There's lots of music sessions going on right now too, where this guy been in drumming for 50 years, and everything he worked on but didn't get credit or paid on.
Yeah.
So there's lots of that.
Right.
Other places as well.
Oh yeah, it's very common across creative industries. So no matter what creative industry you're in, getting things in writing up front is absolutely critical. And anyone if you get onto a team where someone's like, oh no, we shouldn't do contracts, let's keep everything casual, that's usually a big red flag that person is probably going to take your things and not give you any credit or any money, and you should run away.
Right. Like in the case of an artist making your avatar or logo, if there's no contract in place and they just drew it and gave it to you and you put it on your page, they still own that. So in 5-10 years, they were your best friend, now they hate you.
Yeah.
And they can say, no, you can't use that anymore. But your whole brand is built around that. Yeah, you don't want to run into that situation.
And with that, I think we're at 3 o'clock. So thank you so much for coming out today. We're going to stick around for a little bit after the panel if you have any additional questions. And thank you again.
Thanks, everyone.